The following BLTV program is brought to you by O'Flaherty Law. Please enjoy.
Welcome to Learn About Law. My name is Kevin O'Flaherty from O'Flaherty Law, and today we're going to talk about businesses and probate and how, if you're the executor or administrator of a probate estate, to handle business assets. So first, let's answer the question, are business assets subject to probate? The answer is yes. So probate is required in Illinois if you own $100,000 or more in assets outside of a trust or outside of a payable-on-death account. It's also required if you own any real estate outside of a trust or outside of a deed that provides for rights of joint survivorship, or joint rights of survivorship. So business assets, the fair market value of whatever ownership interest a deceased person has, goes towards calculating that $100,000. There's estate planning techniques you can do to make sure that your business assets don't require your estate to go through probate. But we have a different article and video about estate planning for business owners if you want to check that out at learn-about-law.com. So the value of the business actually goes towards that $100,000 threshold. And if the value of the business and the value of all the other assets that are owned in the business owner's individual name exceed that, then the business will go through the probate process along with any other assets that are outside of a trust. So let's talk about some initial considerations for the personal representative. That's the catch-all term for executor or administrator of an estate. The personal representative to think about if there's a business asset in probate. First, does a buy-sell agreement exist? A buy-sell agreement is an agreement between the owners of a business that may provide for what happens if one of the business owners dies. It might provide that the company or the other owners are required to purchase the shares of the business at a agreed-upon price. Sometimes the business will get insurance to cover this sale. And the buy-sell agreement might be included in the operating agreement if it's an LLC, the bylaws if it's a corporation, or the partnership agreement if it's a partnership, or it might be a standalone document. If a buy-sell agreement does exist, then the role of the personal representative will be to effectuate the sale and monitor business operations until the sale has closed to make sure the business is being properly managed until the sale from the estate to the other owners of the business is completed. If there is no buy-sell agreement, or if there is, especially if the deceased person was the sole shareholder or the majority shareholder of the business, the personal representative should check the will and or trust to see if it appoints any business advisors. A business advisor is someone who might be appointed pursuant to a will or trust to manage the business while the business is in probate. And this takes the responsibility and requirement of managing the business away from the personal representative. Personal representative will still be responsible for looking out for the interests of the estate with respect to the shares of the business, but the business advisor that has been appointed, it might be an employee or another owner of the business or someone else from the industry, will be responsible and liable for managing the business appropriately while the business is in probate until the shares are sold or transferred. So let's talk about, once we've looked at those considerations and figure out what your duties are if you're a personal representative. Are you just effectuating a sale pursuant to a buy-sell agreement? Are you working with a business advisor? Let's assume you're managing the business to some degree and neither of those things are the case. How do you manage the business? The first thing is consider the will and the opinions of the beneficiaries and weigh them heavily in determining whether you want to liquidate the business and then just put the proceeds into the estate, sell the business to a third party, or transfer the business whole to the heirs. This really depends on, again, really what it says in the trust or the will that you should do, and then if the will or trust is silent, then take the opinions of the beneficiaries or heirs into account if you'd like to avoid litigation over the subject. If you're managing the business for any prolonged period of time, you should take the following steps. First, meet with an accountant to audit the financial affairs of the business and get a handle on what the business's finances look like. Meet with key employees to make sure the business continues to run smoothly while you're managing it. Make sure the business is maintaining proper insurance. Retain an attorney to ensure that the business is compliant with all laws and regulations, including workers' compensation laws and unemployment insurance law. And then if you're not going to be an activist manager, you should probably look to the pool of employees or owners or other industry peers to appoint a manager to actually manage the day-to-day operations of the business while the business is going through probate. So next, let's talk about what your duties are as the executor or administrator if you are managing the business yourself. If you're managing, you have the duty to operate the business prudently and a duty of loyalty to act in the best interests of the estate and the beneficiaries. So your role, even if you're managing the business, is not to protect the employees of the business or the customers of the business. It's to look out for the interests of the beneficiaries of the estate. And also to be a prudent manager of the business. And you can be held personally liable if you violate either of those duties. If you choose not to manage the business for a prolonged period of time, but instead to simply liquidate the business, what you have to do is wind up the business by collecting accounts receivable or making your best efforts to do so, selling the assets of the business, and then distributing the proceeds from the sale or the accounts receivable collection first to any creditors of the business and then the remainder to any beneficiaries of the estate. You'll distribute it to the estate itself, and then as the estate is wound up, that's when the beneficiaries get it. Let's talk about quickly some estate tax considerations. I'll talk about this briefly because this is pretty complex and outside of the scope of what we're talking about here. But if estate tax is an issue, the last thing you want is to have to liquidate the business in order to cover estate tax if that's something that can be avoided. So there's some laws that allow you to defer payments of estate tax over the course of years in order to avoid liquidating the business, or create a lien that uses the business as collateral for the repayment of any estate tax owed. So be aware that if there aren't enough other assets to pay any estate tax that's due, there are certain things you can do to defer estate tax in order to avoid liquidating the business to cover the estate tax. Finally, we'll talk about a business appraisal. Having the business appraised is not always necessary, especially if you're just going to transfer the business to a single beneficiary or split it equally among beneficiaries, or if you're going to sell the business or liquidate it. An appraisal of the business might be necessary if there are estate tax considerations, so the value of the business plays into whether estate tax is going to kick in or how much you're going to have to pay in estate tax. Whether probate is going to be required. So if the value of the business it really is on the fence in determining whether probate is going to be necessary, it's usually worth getting it appraised if you think probate might not be necessary. If the business is being sold to a third party, it might be good to get an appraisal to establish what the value is before selling it. If the value of the business impacts how assets are going to be allocated among multiple heirs. So let's say one heir is going to take all the shares of the business and another heir is going to get the dollar value of those shares to compensate for not getting those shares, then you probably want to get the business appraised to find out how the assets should be allocated among the heirs. And finally, it may be necessary to establish the basis value of shares passing directly to the heirs for income tax purposes. So that's an overview of how to manage business assets in probate. It adds a whole different complication to a probate estate, so obviously be sure you're working with an attorney to protect the interests of the beneficiaries and protect yourself from personal liability, and getting a good set of advisors around you will really help the process of managing a business in probate. If you have any questions, you can leave them in the comments section below this post at learn-about-law.com or below the video on our YouTube station. If you need some help, give us a call at 630-324-6666. That's 630-324-6666. We offer free consultations in many areas of law, and we have offices in several geographic locations for your convenience. If you found this helpful, we'd love it if you'd subscribe to us on YouTube, SoundCloud, Apple Podcasts, or wherever you listen to your podcasts or watch your videos. Thank you so much for watching and listening.
Thanks so much for watching our video. If you have any questions, feel free to comment below. Click the subscribe button for new videos every week, and download and review us on iTunes. Visit learn-about-law.com for other legal-related articles and videos. Visit our business podcast and video blog, seizeyourbusiness.com, and visit Making Real Estate Fun for real estate videos and podcasts. Call us at 630-324-6666 for a free consultation.